This time, the defense renews all previous motions and objections and moves for its second judgment of acquittal. Your Honor, the standard is now changed, and that is that no reasonable juror, beyond a reasonable doubt, will be able to find Mr. Miller guilty of the offense charged, which is resisting without violence. I'm going to ask that Your Honor incorporate all of my arguments on my first JOA into my second JOA.
Yes, sir, I'm doing that.
And that the standard is now different, it's beyond a reasonable doubt, and that beyond a reasonable doubt, no reasonable juror.
I don't think that's true. I think it's no reasonable juror.
No reasonable juror, beyond a reasonable doubt, could find, no reasonable jury could find Mr. Miller guilty. Specifically, I point to the evidence, I point to the lack of the evidence, I point to the fact that Mr. Miller was arrested 3 blocks away from a public forum where the police officers were giving him an order to disperse back 3 blocks ago. Right before he's arrested on the video, Your Honor doesn't hear any orders being given to Mr. Miller. There's no longer any more orders being given to anyone because there's nobody left. And essentially, Mrs. Perez, or Nancy Perez, arrests him because he is he had upset her earlier in the night by, and she, by her own admission during her testimony, by using the F word with her. So she knew who he was, she was watching him, and when she had the opportunity to come into close quarters with him on the sidewalk, she decided to arrest him. And there was no lawful duty being executed at that time. At that time, if you believe the witness that just testified here, if you believe the police officers who testified, the event was over. That's it. Everybody was going home, and he's arrested. No lawful duty, and even if they had asked him at that point to leave and given him the specific order, which is not on the record, he would have been able, and it's our position to say, no, I'm not leaving. I'm going to stay right here. Also, Judge, if you look at the video, the evidence is that he's walking in a direction, and it's the same direction everybody else in that group, including the police officers, the civilians. There's a gentleman on the screen that's wearing shorts. He's walking in the direction that Mr. Miller's walking in. And Mr. Miller was singled out and arrested. It's clear that the police officers in this case singled out Mr. Miller. They've been watching him. Rick Bravo testified earlier that Mr. Miller was wearing a bandana, that he zoomed in on him, that Mr. Miller got close to him when they were standing on the sidewalk and asked him, why can't I stand on the sidewalk, challenging his authority. Nancy Perez was around Mr. Bravo the whole time, if you believe her testimony. Taking all those things into consideration, this was a vindictive arrest. This was arrest, I pissed off the police arrest because I wasn't nice and polite when I was talking to them. That's what happened here. The arrest happens three blocks away. There are people who are journalists that were there that night that even though they didn't have journalists written all over their shirt, that were treated differently than Mr. Miller. And that's not just, Your Honor. I think any juror, hearing the evidence as we've heard it, no reasonable juror will be able to find Mr. Miller guilty.
Comments from the prosecution?
Judge, I'm just relying on my previous case law, especially the JM versus State. There are actually much more warnings given in this case than in that case, and in that case an adjudication was upheld. We've also heard extremely conflicting testimony about how Mr. Garvin was behaving as opposed to how the defendant was behaving, and how normal journalists would behave as opposed to protesters. Given all of the evidence that we've heard, that over a period of 3 hours, Mr. Miller was told 10 times to leave. He was finally told, if you don't leave, you'll be put under arrest, and he refused to leave. He was the last person pushed out, then he walked back into where he was pushed out of. The state has shown that a reasonable juror could find him guilty, and therefore we would ask Your Honor to respectfully deny the motion for judgment of acquittal.
So I have jury instructions that are printing now. If you could get them from my chambers, I'd really appreciate it. Thank you. Ultimately becomes the same exact arguments from the first motion for judgment of acquittal, with a slightly different standard for myself. That it's just no reasonable juror could find that Mr. Miller was resisting an officer. It was a very chaotic time, January 31st. Well, there was a fact question about whether Mr. Miller was the target of specific orders to, to clear out an area or take a particular route for egress away from the government center. That's a fact question. A reasonable juror could say that he was so informed. There are also very vivid pictures that came out of the video. They showed, not mildly, but a very strongly animated crowd shouting and screaming and bowling a fist and pushing and protesting and a lot of anger. There's almost a stereotypic view of armored police officers, this RDF force marching in tight formation, establishing perimeters, corralling folks away from the government center. And there appears in one of those videos the defendant kneeling with a camera lens going upward right into the march from like a dog's point of view, looking up into the faces of the police officers as they're basically creating a safety line for themselves and a perimeter away from the government center. Like I said, the question is, was he doing proper police work, proper newspaper work, reporter's work, or had he been told, no exceptions, get out of this area? The defendant's witness, the Herald reporter, knew that there are boundaries to where officers, where reporters can go, and that's the fact question. The motion is denied. Jury instructions are coming in. In a moment, we'll have a chance to review them.
You have an extra copy, Judge?
I got 4 copies. They're all coming right now.
We haven't had the chance yet to discuss the proposed jury instruction.
I can talk about it. What do you say?
I checked completely to it. It's a misstatement of the law. According to Wheeler versus State.
Judge, I'd like to get a copy of the case while the state's relying on it. Keep relying on these cases and they don't get the copies.
We give you a
Give
copy
you
of
a copy
every
of
case.
everything that we've relied on so far. I only have one copy of this because we weren't aware that a proposed jury instruction would be submitted and I had to print it out on break, but copies can be made.
What is the nutshell of what you have?
Okay, basically, in order to be entitled to special jury instruction, the defendant must prove 3 elements. That the instruction was supported by the evidence, that the standard instruction did not adequately cover the theory of defense, and that the special instruction was a correct statement of the law. The state points to element 3, that the instruction is not a correct statement of the law, and that it's also not misleading or confusing. This proposed jury instruction is extremely misleading and confusing. It's very long, and it's also a misstatement of the law. It's a misstatement of the law because the case law in Happ versus State, which cites Wilkerson versus State, which stands for the proposition that basically resisting without violence does not infringe upon free speech. 843.02 does not infringe upon free speech.
We're not talking free speech, we're talking freedom of press.
Correct, but that's more or less what the jury instruction is speaking to, Judge.
This is talking about free speech?
In Wilkerson versus State, which I'll hand to counsel right now,
Yeah.
the court holds, may I approach, Judge?
Yeah.
The court holds that the statute, 843.02, was not susceptible to any limiting construction that would save it from impermissibly curtailing the right of free speech under the First Amendment. That amendment, the court stated, requires that police officers respond with restraint in the face of verbal challenges to police accusation, as a certain amount of expressive disorder not only is inevitable in a society committed to individual freedom, but must itself be protected if that freedom would survive. That's verbal, dealing with verbal challenges. But police officers may lawfully demand that citizens move on and away from the area of a crime without impermissibly infringing upon the citizen's First Amendment rights. And it also goes on to state that we do not construe the language of section 843.02 as reaching protected speech. Therefore, the third element of the Supreme Court case of Wheeler versus State, which deals with special jury instructions, that the special instruction is a correct statement of law, is not met in this case. This entire jury selection is a misstatement of the law, and the state objects to it.
All right, Judge, they can say that all they want, and my response to them is that our entire theory of defense is premised on the fact that Mr. Miller acted lawfully because the state deprived him, or the police in this case, deprived him of a right secured to him by the First Amendment of the United States Constitution. The police officers, we agree, I mean, we allege as our defense that they unlawfully deprived him of his rights and privileges in that he had the right to assemble.
Freedom in the Constitution.
What's that, Judge?
It's actually called a freedom in the Constitution.
Right, it's a freedom. And, you know, specifically, the police can give a lawful order. Number one, that's up for question as to whether the order was lawful. Then the other issue is, was the order even given to Mr. Miller specifically? But even if we believe for a second, taking the state's theory, that Mr. Miller was ordered to leave the public sidewalk where he was, he has a right to be on that public sidewalk, to videotape the police, to record them. It's his First Amendment right. There is no jury instruction, a standard jury instruction, that covers that issue. The jury will be incredibly confused, and their questions are going to be, well, did he have a legal right to be there? Does he have a First Amendment right to be on the sidewalk? And the state has to prove that, beyond a reasonable doubt, they did not deprive Mr. Miller of his First Amendment right to be on that sidewalk. It's a factual issue. It has three parts.
Of the crime, and it's
And if
also
I can
a
finish,
state law.
because I didn't interrupt the state when they were talking.
Your protest is appropriate, Mr. Bernard. State.
I apologize.
Okay. The factual issues, Your Honor, has three parts. First, they must determine the defendant's intent. The defendant's deaf and doesn't hear the lawful order. What was the defendant's intent? Did he act in good faith in exercising his constitutional right? Was he doing it just to create conflict and to create interference with these police officers, and is just using it as an excuse? That's one thing they would have to determine. Secondly, they have to determine whether the actions of the police officers interfered with Mr. Cardinal's exercise of that right. They have to determine whether the actions of the police officers interfered with his ability to record, write, document, or publish the media. They must determine the intention of the police, and Judge, the intention of the police in this case is part of our defense. What were the police's intentions? We allege that the police had it out for Mr. Miller from the beginning. From the moment he ran his mouth, that he said some things to the police officers that they didn't like, that were protected by the First Amendment, they were out to get him. And they can't use a statute or a law such as resisting or disorderly to infringe upon his First Amendment rights. And that's exactly what they did in this case. The jury should be apprised of what Mr. Miller's First Amendment rights are. They should know what they are, because they're not anywhere in the standard jury instructions. I mean, this isn't an instance where, there's a murder scene and they're asking him, he doesn't have any First Amendment constitutional right to remain at a murder scene while they're conducting an investigation and photograph. This was 3 blocks down. This was a public forum, which is one of the most protected forums, which is a public sidewalk. We're not talking about the government building anymore. He has a right to be there. And the jury has to make the determination as to whether they infringed on his First Amendment right. It's kind of like the instance where the police are coming into a neighborhood and the kid yells out, 5-0, 5-0. He is alerting other people that the police are coming, and there's case law it's clear, it's been established that he can do that. That's a First Amendment right that he has. And the jury, when they're determining whether his statement is a criminal act or is interfering with the officer's investigation, they have a right to know that he has the right to say that. I mean, so they should be instructed on that he has a right to record, he has a right to freedom of expression, and they have to prove that the state and the police in this case didn't infringe upon that right. That's why we're requesting this instruction. There's no standard instruction that goes to it. It is directly on point. It is consistent with the law in the state of Florida, especially the First Amendment of the Constitution. I don't misstate the First Amendment of the Constitution in any way. I've crafted it in a way that is fair for both sides. If they find that he, part of the state's argument was that he was using this camera and this whole photographer thing as a front, because he has a photography, is not a crime blog, and his whole thing is to confront and challenge authority. That's written into the proposed jury instruction. They have to look to his intent, and if they think that he's a phony, that he just is looking to start conflict, then he's not protected by the First Amendment, and they're going to be instructed on that because it's in the instruction. So it's a balanced, it's fair to both sides, and we're requesting that Your Honor include it in the standard jury instructions.
In its entirety. You want it in its entirety?
Yes, Your Honor.
Judge, would you like me to respond?
If you want to.
They're basically saying that resisting without violence is unconstitutional.
No, that's not what we're saying. That's not what we're saying. We're not challenging the statute at all.
The First Amendment is not an affirmative defense. If they want to assail 843.02 as unconstitutional, they can attempt to. However, it's already been determined that that statute does not infringe upon free speech. This is a manifesto on the First Amendment. It's a misstatement of the law as it relates to this case and this charge. I've already cited for you.
I still think that this isn't, it's not about
It's not about the First Amendment.
speech. Well, freedom of press is what this is about. This is about reporting an incident as it's occurring.
But 843.02 goes to conduct.
Right. His conduct was
And the
being
state
in
of
a
the
particular
law,
place at a particular time to record a particular event.
the state of the law as it goes to these types of statutes, I referred, Your Honor, earlier to Cox versus State of Louisiana, that's a Supreme Court case, is that dealing with a picketing statute, we hold the statute on its face as valid law dealing with conduct subject to regulation. It's dealing with conduct, not with First Amendment issues. The law on First Amendment issues is that it can be curtailed subject to valid time, place, and manner restrictions, which it was in this case. And the facts of this case would support that Mr. Miller's First Amendment rights weren't hindered. This isn't about suppression. This is about his conduct in refusing to leave. So this jury instruction is going to be extremely misleading, confusing, and it's also a misstatement of the law that's going to be highly, highly prejudicial to the state in its entirety.
All right. By and large, I agree with the state that the proposed jury instruction will be marked for the record, put into the record, Yvonne, so we know what it is that he wanted, and that can be reviewed if they want to review it. What I had put in there is something that Mr. Trevilla has touched on. Let me go through the jury instructions now from the top with you. There is a special that's in there. The standard jury instruction 22.2 was tracked by me precisely. I want to make sure you're in agreement. We have members of the jury, thank you. We have the defendant in the case accused of resisting without under 202. We have the restatement of the law on it to prove the crime of resisting an officer without violence. The state must prove the following elements beyond a reasonable doubt. Carlos Miller resisted, opposed, or instructed Lieutenant Diepa and or Major Perez as he or she was engaged in ordering a special and or related commands. State, are you okay with that paragraph? You can come back if you want to look at the totality.
Just for the record, the clerk's back, and Your Honor instructed her to mark the proposed jury instruction.
Please mark them and put them.
Oh, you heard it?
Yeah.
Okay.
I've been
I didn't see her.
It was here the whole time, and it's here, Yvonne.
You have it.
It's
No,
here.
you have it on front.
Are you okay, State?
Judge, I think paragraph 1 is a misstatement. That he opposed by resisting their lawful command. He didn't oppose them giving a lawful command. He resisted the lawful command.
All right,
So if we could change that.
all right. It's
You want these?
Judge, which paragraph are you on? The first. You're talking about the standard jury instructions that we have here, right?
the same ones.
How are you proposing to change it? Because I think it's fine. I'm not sure if I understand the state, what the proposed change is.
I think the word "was engaged" makes it awkward. How about he or she ordered a dispersal and/or related commands, and/or gave related commands?
I think that to track the language of the information, it would be more appropriate to put failing to obey a lawful command. Or,
You see, you're changing the subject, I think. It says, the defendant resisted, and at the time, the victim was engaged in these things. It's what was the victim doing? Number two, if you look at the jury instruction. One would be, resisted, opposed, or obstructed, just the Dieppe and Paris, period. All right, that's, and that other stuff will be taken out. That's what the standard talks about. Number two says, at the time, these two were engaged in lawful execution of a legal duty. Right, now you can argue about that. So you have powers to argue what that execution of a legal duty was. And the defense can argue that it wasn't a lawful duty, a legal duty. Number three, that they were law enforcement officers. All right, and number four, at the time, the defendant knew that these two officers were officers. All right. And the next one is, at the time, the court now instructs you, I should put that in there, right? The court now instructs you that every Miami-Dade police officer is an officer within the meaning of the law. I'll put that in there. Now, what I put as the special was for the defense, Mr. Trevilla, is that an issue in this case is whether the defendant heard from law enforcement officers commands for dispersal and/or commands for leaving the protest area on a specified route, and/or whether the defendant knew that he was not to re-enter a protest area that he had that was cleared out by the law enforcement officers. Is the state okay with that?
Hold on a second.
Is the defense okay with that?
Give me just a second.
Judge, I think we need to add sort of a follow-up to that, to indicate that if the state has not proved that he heard it, then he must be found not guilty, or something along those lines. Because I think.
It doesn't end with, like, what should I do if that's the
I'll
case?
put it there, if you find that it's not proven beyond a reasonable doubt.
There's also a little bit of a typo on the last line. I don't know if the state brought that to your attention.
It was hard for me to, concentrate on your presentations while I was doing jury work. It was fine that that has not been proven.
Judge, I have another proposed instruction. I didn't think you were going to deny this
Let
one.
me just finish this.
Can I make a phone call, Your Honor?
Yes.
You need this?
Yeah.
Oh, okay.